Okay, state content review. Are we ready? July 21st. Here we go. Let's get into license requirements, maintenance, and education. Now, on your state exam, they will probably break this down into maybe 2 different categories, like for each. I've got it bundled together because I think it's easiest for you to learn it this way, to be really honest. This is one of the top 3 categories you need to embrace in order to pass the state exam. It is license, maintenance, and education, and license requirements, 8 test questions. And then, of course, agency and contracts are the other 2 big ones. So if you want to know what to study, those are always going to be my top 3. But this is a big nugget and a lot of good content for you that you really kind of already know because you're in the process of getting your license. So a lot of this you've been studying and studying, just to get here and even signed up for a pre-license course. With that, I'm on page 4 of your handout. And the first thing I want you to know is the mission of the Real Estate Commission is to protect the public. I know this is confusing because we have the Real Estate Commission, that's our governing body, and then we also make money as commissions, right? Here's the deal. Let's say you and I do a deal together and we squabble over the commission dollars that were available to be shared amongst each other. I don't pay you what I said I would. Do you go to the Real Estate Commission for that? No, ma'am. No, sir. You are going to probably have an attorney write a strongly worded letter. You'll maybe start there threatening me. No. But that's probably where you will start, is some sort of letter. We'll maybe try to even hash out on our own. We'll maybe hire a mediator. We'll go to court. We'll go to small claims court, but we won't go to the Real Estate Commission. Another way that they might ask this for you on the exam is it might not be so simple as the mission of the commission is to protect the public. They might ask it in the fact that they regulate licensing, maintenance, and discipline, right? That they set standards for you. It might be asked a little bit more complicated than that, but the theme is they're regulating standards that you've got to have a license in Iowa to receive a fee in exchange for your real estate activities. Okay. The other thing I wanted to go through with you on page 5 is we know that we've got to have a real estate license to negotiate, advise for our clients when it comes to real estate. We know that we've got to work under the managing care of a broker if we're a salesperson. We know that the contracts and the compensation belong to the broker, and they're going to pay you according to your independent contractor agreement. We talked about that so much, and we'll probably do it again. Let's face it. Here's what I want to note for you, though, on page 5 is the times that you can practice real estate and not need a license. Now, there are 11 examples in the actual code. I'm going to give you 3 that I think you need to focus on. Number 1, you can do a for sale by owner and sell your own home and not be licensed. You own it, you can sell it. Again, that's a FSBO, FSBO, for sale by owner. The second one is power of attorney, and we discussed that this morning. A power of attorney is a written legal authorization for someone to conduct real estate business on your behalf. So a power of attorney does not need to be licensed. They're just basically a legal extension of you in terms of decision making. Okay. And then number 8, a resident manager for a property who resides in the dwelling in combination with their management services. So a resident manager for property manager a manager that lives on base, lives on premises, is also excluded. Those would be the 3 I would review that I think would be most suspect for you. Now, salesperson license requirements goes into page 6, and you've got a lot here. But I think you already know the 60-hour pre-license. I think you know you've got to pass an exam. If you've not caught on to that by now, Godspeed. God bless your heart. I think you also know that you've got to do those 3 12-hour courses: listing, buying practices, developing professionalism. Now, just as a reminder, you only need to finish this class to take the exam. You don't need to do the other 3 or the background check. Those things are required for application, but we're just going to finish this. And obviously, you guys are very prepared to take the exam, it sounds like. Here's where I think your highlights are. You cannot get a real estate license and then decide what broker you're going to work for. You've got to have a managing broker commit to you with your license application. So that's going to need to be a part of it. And it's really, really simple. You will just request a broker. The commission sends them an email. They check a box saying, yes, I will take Amy Schaefer. It's pretty easy, but make sure that you know that your broker is doing that, or that your broker knows that you're applying, because sometimes those commission emails go to their junk mail. And I don't want them to miss and that delay you getting your license, okay? So make sure that you've got a broker selected before you apply. That's a requirement. We obviously know you cannot work independently without a broker. You've got to be 18 years of age or older at the time of application. 18 years old. They're going to try to mess with your head, make you think it's 21, like smoking and drinking. No. 18 is the number. Then here's another big one, and I'm just going to read this from the code because I've seen it worded like this almost verbatim to the code. But an applicant is not ineligible because of citizenship, sex, race, religion, marital status, or national origin. Although the application form may require citizenship information. So it's not a reason to be ineligible, but they may require it as the application. I've seen that almost verbatim from, like I said, the code on the exam, but I've also seen an exam question that talks about someone's visa expiring. That doesn't mean that their license automatically expires. It means just their citizenship does. So they might need it for application, but it's not a reason to deny it. There's a weird question out there I've never been able to memorize. So if you see it and you can memorize it, let me know. No, don't worry about it. Pass the exam. Don't you worry about me. I'll go retake the exam here the next 6 weeks or so. Then I also want to make sure that you know at the bottom of page 6 that licenses are issued for 3 years. And the first year counts as a full year no matter when you get your license. And all licenses expire on December 31st. So if you get licensed August 20th of 2024, you got the remainder of 2024, all of 2025, all of 2026. So your deadline to renew is going to be by December 31st of 2026. 3-year term, first year counts as a full year. No matter when you're licensed, whether it's January 1st or December 30th, counts as a full year, 3-year terms, all licenses expire December 31st. Broker application. And this is great because there's a lot of overlap and duplicate here. Broker applicants must be 18. I know what you're thinking. You got to be older. Nope. 18 is the number. It's the same for both. That citizenship is the same for both. They're not ineligible because of his citizenship, but that information may be required on the exam. Here's what you do need to know about broker. You need an additional 60 hours of pre-broker, and you must be actively licensed for a period of at least 24 months before application. And here's my loving reminder that 24 months equals 2 years. So your brain doesn't do a flip-flop on you. Okay? But here's the deal, you just have to be actively licensed. On the exam, it might ask if you have to do a certain number of volume or a certain number of transactions or something like that, but there's nothing related to production or leadership. It's literally that you're actively licensed. Okay? And then the same thing with your license as a salesperson, same thing with brokers. No matter when you get your broker's license in the year, the first year counts as a full year. You've got 3 years to renew. Deadline is always December 31st. And then I wanted to add, I need to add this to a different page in my notes. One thing I want to add to your license application for a salesperson and a broker is you must apply within 6 months of passing the exam. So if you pass the last day of the 6th month, let me even clarify. It's the last day of the 6th month. So that means if we're licensed on May 16th, for example, we've got to June, July, August, September, October, November is the 6th month, but it's not November 16th. It's the last day of November. So 30th would be the date. Great test question. And for the cheap seats. Now let's talk about license, maintenance, and renewal, because you've got several categories of test questions here. And Mimi, I know you love some of these. You were all ready for it. I remember that from the other day. To renew our license, broker and salesperson, we need 36 hours of continuing education every 3 years. Of that 36 hours, 8 of it must be law update and 4 of it must be ethics. Those are 2 mandatory courses that you've got to have to renew. The other 24 hours can be electives of your choice as long as they're approved with the real estate commission. Lots of different topics you can take. Now you can renew your license without continuing education, and I recommend that you do it. Don't let it lapse. If you renew your license without continuing education, though, how are you renewing it? Inactive. Okay. And anytime your license is inactive for whatever reason, that means the real estate commission technically has it. You're not selling real estate. You're absolutely not selling real estate. Now let's get in further to these license renewal requirements on page 8, kind of towards the top. The law says that if you fail to renew your license by December 31st, they give you a 30-day grace period to January 30th. But do not mistake grace period. Grace period means that they will let you activate your license with a $25 fee for the month without starting your application from scratch. That's the grace. But you are inactive during that time, so you're not selling real estate. I know a lot of agents think, oh, grace period means if I didn't renew, still sell real estate and just get this done by the 30th January. Hard no. Hard no. The moment you didn't renew, you went inactive. You cannot sell real estate. The grace they are giving you is that you don't have to start from scratch with your application Or God forbid you retaking all of these pre-license courses, right? They're just they're giving you that grace period, 30 days, $25 a month, $25 penalty. Then if you go past that January 30th grace period, they will allow you to go up to 3 years with a penalty of $25 a month. And after that, if you don't get caught up, then that period lapses and then you would have to start from scratch. So $25 a month for up to 3 years. And if you don't get your poop in a group by then, there, I said it, then you will need to start from scratch. You don't want to do that. The other thing on page 9 is errors and omissions insurance. When you are actively licensed, you must carry an individual errors and omissions insurance policy. Please do that. Very, very important. Very important. Then license termination and transfer. So let's say you just go in one day and your broker says, Amy, no more. You work here, no mo. And they send your license back to the commission and you're inactive. You're not selling real estate. Carolina, though, go ahead.
Was the errors and omissions, was that something that you advised that we talked to the broker about?
Yeah.
Okay.
Just because I don't want your State Farm guy to bid it out. Nothing against State Farm, but they maybe just don't know what our law requirement is for minimum coverage. And that's not really something that they maybe specialize in. If you would have to file a claim, the reason I like your broker to do it is they may want you to have a policy that speaks to their firm. So I like to have my firm policy match with the same company as my individual, right? That's my business choice. And I just want to make sure you've got a broker that can coach you on it. Thank you. That's a good point. So if your broker fires you, you're inactive, you're not selling real estate. But what if you go in one day and you get really hot and heated over something at a team meeting? They're changing an office policy. And you go into your broker and you say, take this job and shove it under the refrigerator. Someone gave that to me in a card one time with a black cat on it, because I used to have a black cat. It would be a set, like for Seth's cat, take this job and shove it into the refrigerator like a cat toy. So that's why I say that. But let's say you go in and you do that. They're going to return your license to the real estate commission. And what? You're not selling real estate. You're inactive. But if you do want to make a transfer and keep your license active, but move to another brokerage, here's what you need to do. Page 10, 3 steps. Number 1, find a new broker that will take you. You got to get a new one first. Second step, you have the old one release you. And third step is you verify that you want the transfer to happen. Disciplinary actions, you've got 4 questions here. And I'm just going to hit a few things that would get you in trouble that I think are common. You've got a list of other things you could review here, but this is a speed review. Undisclosed dual agency will get you in trouble. Accepting a commission directly from a client will get you in trouble. Now, let's say you go to a closing and they say, Amy, you did an amazing job. And you're like, I know. And they say, we would love to pay you a bonus of $2,000 because we would have never been able to buy this house without your guidance. I know. Can I, as a salesperson, accept that commission? Hard no. Now, I cannot take it personally, but if they really do want to pay that bonus, it just needs to get paid to the broker. It's got to be documented in writing, and then your broker is going to pay you according to whatever your independent contractor agreement states. Okay? Those are the 2 that are like disciplinary action. And then another one I'm going to throw in here, even though we're going to talk about it under contracts, is present all offers. Present all offers. Okay. I don't know that there's anything on the complaint section I can think of, but for investigation procedures, on the middle of page 14, that hearing on charges, absolutely, absolutely. If before the commission can have a hearing about you, they've got to give you a 20-day notice. 20-day notice, and then you've got 10 days to respond to it. I'll add that to your notes, but 20-day notice before they can sit down and have a hearing. Then I would review these disciplinary sanctions and the factors that they will consider on the bottom of page 14 and 15. Now, when they discipline you, these are the different types of discipline that they could assign and do a combination. Revoke or suspend a license indefinitely or temporarily. They could put you on probation. They could prohibit permanently. They could require additional continuing education. So instead of the 36 hours, maybe you have to do more. Require re-examination, monitoring, order a physical or mental examination with periodic reports to the commission. Now, on the exam, I had a question that said, which of the following does the real estate commission not issue as discipline? Which of the following do they not issue? Okay, hold on here. A, revoke a license. B, suspend a license. C, downgrade a license. Or D, order a physical or mental examination with periodic reports. I did not know how to answer that because according to the code, all of those are listed here, correct? Am I crazy? I did not make this up. This is from the actual code. So I asked the real estate commission because I bet most folks don't think that the commission could do a mental or physical examination. But according to the real estate commission, they do not downgrade a license. So that would be all of the following except they don't downgrade a license. I know that's confusing. It's written here. So you might want to do like a line through that one, but don't totally erase it with squigglies. Just put something like, according to commission, they don't do this, but that was the right answer. I got that one wrong because I didn't know what to say. But according to the commission, of those four, they don't downgrade a license. They revoke, they suspend, they can order physical and mental examination. So that was one question. Another question I got about discipline of the four was about the civil penalty. And the maximum civil penalty that the commission can issue is $2,500. Now, I forget how it was worded, but they really tried to lead me down the road that it was 5,000. They really did try to trick that. But it is 2,500 per violation. Per violation. Now, another thing that you might get questioned is, what are some factors that they might consider when they're issuing a discipline? Are there other forms of discipline that's already happening with this? Or do you have an ethics violation with the local board of realtors? Do you have a judgment against you in court, right? They might consider some of those things. The circumstances, the severity, what type of economic benefit you have. I would highlight, though, the time lapsed since your last disciplinary problem. I would highlight whether the violation is repeat or offense, a repeat offense, whether it was intentional. Those three I know I've seen as options. I know I don't have a fourth for you there, but I would review this list of things that they would consider. Have you been in trouble before? When was the last time you were in trouble? How much were you willing to cooperate and provide evidence? Was it a large financial gain for you? What was it specifically malice in terms of like revenge or intention? We've seen that happen. Agents didn't get a listing, and so they did something very revengeful. They wrote an offer with a fake buyer and let those sellers think they were under contract. I've heard that story before. It's very intentional, right? That's very retaliational. Believe it or not, I've heard worse than that. Page 16 is that tie-in agreement. That is prohibited, where we refuse the sale of a lot to that home builder. We can't do that. We cannot refuse to sell if we just so that we get a listing. Those have got to be two separate contracts. They can hire you to do both. You just can't tie them together. Also an antitrust law. Those are my highlights from that section. I know there's a lot more content there, but 4 test questions on that one for you. Trust account starts on page 20. You got 3 test questions on this one, and you've got a lot of options. Number 1 on page 20 in the middle, know that when a broker sets up a trust account, it's got to have the word trust in it. So Amy Schaefer Real Estate might be my regular account where I accept commission checks and pay my real estate bills. But my trust account that is that escrow account for other people's property, for their deposits and earnest money, that would need to say Amy Schaefer Real Estate Trust account. It's got to have the word trust in it. And then also know that it's got to be an interest-bearing account. And the interest must be transferred to the state on a quarterly basis. The very bottom of page 20, we've got to make those deposits in 5 banking days. It might say business on the exam, but 5 banking days. 5 is the key. On page 21, know that the broker can have up to $1,000, according to the Iowa Code, up to $1,000 of their personal money in a trust account. Now, I know we talked about commingling and coercion, that we don't want to mix, but the Iowa Code allows up to $1,000 just so that the broker has money to maintain the account, order checks, maintenance fees. And most banks don't allow you to open an account with $0 and maintain $0. So that's why they're allowing just that little pad in there. Here's the other thing that we need to review is releasing trust funds, bottom of page 21. When we get an offer accepted between a buyer and a seller, and let's say the deal falls apart for whatever reason, we've got to have a written authorization between the buyer and the seller on how we're going to release that earnest money. Now, our standard real estate contracts say that if I do an earnest money deposit of $1,000, that gets held in the listing broker's trust account and it stays there until closing. And the contract says then at closing, I, as the buyer, get that back as a credit. So if I need to bring $10,000 for my down payment, I already made $1,000 deposit and now I just need to make a remainder 9,000, right? But if the deal falls apart, we've got to have written authorization on how to release it, which means you need to work with your clients to have them sign an agreement. And if you can't get it worked out, they need to either go to mediation or court and figure it out. But we've got to have it in writing what we're going to do with it. Now, there's more levels to that a broker is able to do, but I don't think you need that for the exam right now. I think it would be too much. At the top of page 22, a broker can never keep earnest money to cover their commissions, even if they're due a commission. That's not their money. And if the offer is never accepted for whatever reason, the buyer revoked it, withdrew it, the seller rejected it, or never responded to it, it expired. If the seller never accepts an offer, that's when the broker can immediately return earnest money, no questions asked. Then closing a transaction. Brokers got to retain records for 5 years. That one's actually probably a broker responsibility question, but it's here on the code as well. Here's what we need to know about earnest money. Whatever you write on the contract for money, it's got to be cash or an immediately cashable check. So if I write $10,000 for earnest money, hypothetically, I've got to give cash or an immediately cashable check. I can't be like, surprise, here's my Nintendo 350 or whatever, and my Beanie Baby collection that according to eBay is all worth $10,000. No, you write 10 grand in there, it's got to be cash or an immediately cashable check, okay? Here's where it gets a little deeper though. Could I use my Nintendo, whatever, PS93? I don't know. I think I'm confusing the name. Could I use my Nintendo as an earnest money deposit? Yes, as long as it was disclosed in the original offer and the seller accepted it. On the exam, I've seen them ask you about an item of jewelry, like a diamond ring. Can you use that? Can you put a ring on it? Yes, you can, but it's got to be disclosed with the original offer and the seller has to accept it. There, I did it. I met our goal of referencing Beyonce today because I know that was your goal when you woke up. And again, on page 23, we've got to maintain records for 5 years. Again, I think that's a broker question, broker responsibility, but it's here too. Agency. Page 24. Now, we've got law changes effective July 1st, where we now have to get signatures from buyers to show property, especially if we're going to be providing specific assistance. It excludes open houses. But for the exam, I'm not going there with you. You come back to me for buying practices. We will talk about it there. If you've already taken buying practices with me before the law took effect and you want me to do a little rundown, let me know. Maybe I could even do a video on that for you guys. But to pass this test, I know that the questions have not been updated yet. I mean, I'm confident, I guess. So what you need to know about agency is it's got to be made prior to specific assistance, which means you are learning confidential information about that client. And before you learn that confidential information, you either orally or in writing have got to let them know, here's how agency works. The difference with the law that we're running into is there's some oral version of it. It's in writing now. It's in writing, okay? The other layer of that is that we've got to have that signed, though, prior to a buyer writing an offer or a seller accepting it. So it used to just start as verbal, and it didn't need to be in writing until we were writing offers or a seller is accepting it. Really, what this new law is changing is we gotta have it in writing from the beginning. There's no oral conversation anymore. It's in writing. That way we've got clarity. Also, of course, we've got single and dual agency. Dual agency must be disclosed. Under confidential information, on page 26, you'll absolutely have a confidential information question. I think the example that I gave you at some point was, which of the following is confidential? They've been looking for 6 months, they're pre-approved, their parents are gonna come with them for showings, or they need a specific school district for a special needs child. And I think we all agreed that that was D. That would be an example, but I think you'll absolutely have a confidential information question. So 26, page 26 is a great review. Motivating factors, their real estate needs, any financial information, that they would take more for the property or they would pay more for the property as a buyer or less as a seller. Really good review, but that's my highlights. Then as we go into single and dual agency, we know that we've got to present all offers no matter what. As a buyer's agent or a seller's agent, we've got to present all offers no matter what. One thing I want to highlight as single versus dual agency. Dual agency, as I've been saying, must be disclosed. That's the Iowa law. But also with dual agency, and this probably goes into page now 29. We're skipping ahead a little bit. On page 29, it states that a dual agency disclosure, that's a tongue twister. A dual agency disclosure has got to have a comment in there that says by representing both parties, you cannot represent one in detriment to the other. You can't play favorites. You basically have to be neutral territory. And then here's another one I think you could be asked multiple times on page 31. Is that licensee interest in a transaction? The law says that you can represent yourself or immediate family, but you've got to disclose it. You can represent yourself or immediate family, but you must disclose it. So for your career, if you were buying a property, you yourself, it would say buyer is licensed in Iowa, or if you were selling, it would say seller is licensed in Iowa. If you're representing immediate family, you would put agent is related to buyer or agent is related to seller. That must be disclosed. For your career, I always put that in agent only remarks. If I'm selling my own property, in the private remarks that just agents can see, I put seller is licensed in Iowa. Okay. Or if I'm representing a family member, I would put that there as well. And then I always make sure it's always on the contract as well, maybe in something labeled other provisions or something like that. So you want to make sure it gets in front of everybody's eyeballs. But I put it a couple different spots. Okay. Let's get into contracts. 7 test questions, page 33. Again, I keep saying this, present all offers. Present all offers. That could come up with a disciplinary action. That could come up with brokerage agreements and contracts. It could come up at agency. We've got to present any and all offers. We cannot sell or assign our brokerage agreements. If an agreement is transferred to another brokerage, it's got to be with written consent by the client. Now, where I think a question might come up here, and I know it relates to some of the other material, is what if your broker dies? Let's say your broker is your mom. Can you inherit her listings? Those died with her, correct? And if your broker dies, your license isn't active, right? Now, a lot of big brokerages in Iowa, they'll just appoint another broker quickly. But in my case, something happens to me. That's it. That's it. Those contracts go away. And any agents I would have working underneath me now are inactive because they're not licensed under a broker anymore. Okay. And then someone else had pointed out that upon termination or association of employment, that means that the contracts belong to your broker. You can't just take them with you when you go. Those stay. Top of page 34, we learned this in agency on the national. Your contract starts on the date of the contract. That relationship then commences upon closing or completion of the transaction. So again, when is your first opportunity to end a contract for a brokerage agreement or an agency agreement? It's upon performance. It's completion. You had a closing, you did your job. Item B, that first one says that you're to keep all confidential information received during your contract period, unless it's a material adverse fact. Those get disclosed no matter what. We've talked about that a lot as well. We've also talked about not taking an undisclosed commission. All commission has got to be documented. Net listings are illegal in Iowa. That addresses that for you as well. Then just for the record, at the bottom of page 34, it says commissions should not be on a purchase agreement. That is the current Iowa code. It is changing August 14th. We'll be able to have commissions addressed in a purchase agreement. So if that's on the exam, just tread lightly because I guarantee those questions will not get updated right away after August 14th. So just so you know, if that does come up, commissions cannot be addressed in a purchase agreement. It needs to be on a separate document. It does need addressed. The law now says it's got to be a different agreement. We're changing that August 14th and commissions can be addressed on the purchase agreement. Sorry, that's a little confusing with some recent law changes. And I know that the exam just doesn't get updated very quickly. Page 35. Distribution of executed instruments. That means if they sign it, they need a copy of it. If they don't sign it, they don't need a copy of it. A buyer doesn't sign a listing agreement. That's with the seller. So the buyer doesn't need a copy of it. This says under listing brokerage agreements that automatic extension clauses are illegal. Good test question. Now, there's 7 test questions on this contract. So you're like, where are we getting 7 questions from, Amy? You're like blowing through this content. Well, let's slow down. Because of the 7, I've had as many as 3 be just on this one topic. And that says, when can you solicit a listing? And the answer is, if you know or have reason to know that a client has an exclusive agreement, you cannot approach them during their listing period unless what? They approach you first. Oh, I can see your lips moving. I can read your lips. Yeah, I have been asked that multiple times. I've been asked as an exclusive right to sell. I've been asked as an exclusive listing. I've been asked as an exclusive buyer agency. I've been asked as an open listing. If it says exclusive, you cannot solicit someone that you know is under contract with another agent unless they contact you first. If it's an open listing, those sellers contract with multiple agents anyway. You can approach them at any time. So look for the word exclusive. Any word exclusive, you cannot approach them. They must approach you first. But I've had that question on repeat. So just know that of this content, I mean, major highlight that one because I think it could be asked of you multiple times. And I like that because you know what to do with it. Enforcing a protection clause. And this is where we protect the buyers that we attracted during our listing period. So that provision needs to be in the contract. And guys, it'll be pre-written for you guys. It's not something you'll have to handwrite in. It's got to be for a specific period. And any of the buyers that you want to protect, that list has got to be given to the seller prior to the expiration. I would maybe just review that or just even review what that protection clause is. It protects the broker so that the seller doesn't hijack their leads that they created during their marketing efforts and their listing period. Now, I know we've got some things under presenting purchase agreements that we shouldn't alter someone else's commission. We shouldn't negotiate directly with someone's client. And we should not refuse a client from ever having their agent with them. Okay, those are our 3 big rocks as agents, that we shouldn't do that. Basically, we should not interfere with a contract that we're not a party to. I've been saying that, I know, over our time together. Property disclosures, 5 test questions. We know what that material adverse fact is. That is something so significant that it would alter the value, it would pose a structural issue, or it would pose an environmental issue. These are things that the seller must disclose because they could not be discovered by the naked eye or by a regular home inspection. We've used this phrase multiple times, but the disclosure statement must be made available to the buyer prior to writing an offer or the seller accepting it. Prior to writing an offer or the seller accepting it. Then property condition disclosure requirements. Basically, this is saying that if the property condition changes, the seller has an obligation to update the disclosure. Page 39 and 40, I've given you the 19 items that must be on a seller disclosure. Now, you do not need to memorize these 19 items, and I do want you to use your broker's residential property disclosure. There's several different versions of it out there, but make sure you use what your broker wants you to, okay? And it'll have these minimum 19 items on it, but maybe they've got a few extra things they feel like it's important to add. So these are the minimum by law, but you might have a disclosure that has more on it. Or it might be mandatory and non-mandatory. It might be broken up. I've seen that before too. Here's what you do need. You need to know that this residential disclosure is for a property with 1 to 4 units. 1 to 4 units. So we need it for a single family home, condo, townhome, duplex, triplex, fourplex. 5 units or more, we do not need this residential disclosure. Bare land, we do not need this residential disclosure. And then another thing I'll add is the executor of an estate is exempt. So let's say I pass away peacefully during the night, full hair and makeup. My sister is now the executor of my estate. She is exempt from filling out the Iowa residential property disclosure. She will still fill out lead-based paint because my house was built prior to 1978, but she will not fill out the Iowa residential seller disclosure.
It's also helpful to know that it's 558A.
Yeah, that is the Iowa code. And if you go to the Professional Licensing Bureau, it's got links to all of these, this Iowa code 543B, the administrative rules 193A, And then this specifically is 558A. But all those links are right there that go to the legislative law. Anything else on that? 558A? You could nerd out with Serena and I. Groundwater hazard statements. This is a statement that will be created as part of a closing document that the seller signs right before they're ready to transfer the property to the new owner, and it will be part of their deed package. Now, the rules on this have changed, but I'm still seeing exam test questions, so I want to hit this with you. Here's what a groundwater hazard statement covers. GW Bush is my acronym. Groundwater, wells, burial sites, underground storage tanks, sewer systems, and hazardous waste. This is actually a DNR form. They're just trying to track what's going on to protect our groundwater. So we've got healthy drinking water. You might get a question, when must this document be signed? The answer, who can sign the document? Who can sign the document? That's the transferor, seller, or agent, but it says transferor or agent on the form. That's who can sign it. When must it be made available? That's what I was starting to say. But when must this document be made available? It must be made available in order to record the deed. Now, title can still transfer, but we won't be able to record it on public record, which means if that's unavailable, your lender is not going to close because they want that deed recorded ASAP so that they can file a mortgage lien against it right away, right together. So they want that filed. And then the fourth thing that they might ask you is about repairs or remedy of a hazardous waste issue. This groundwater hazard statement doesn't demand that that be fixed. If that needed to be approached, that should have been done as part of the negotiation with your original offer based on the seller's disclosure or with an inspection of the property. This is just a disclosure. This isn't getting to the last minute and there is a well and we've got to have that well filled in order to close. No, that's not what this is. That well was disclosed originally. If you wanted the well tested or you wanted it filled in, that should have been negotiated with, again, the original offer or with your inspection period. This is just a tracking device for the DNR. Okay. Now, broker responsibilities and assistance. You've got 4 test questions here. And guys, I think you know the basic summary of this is to provide cold AC. Care, obedience, loyalty, disclosure, accounting, and confidentiality. That's really what this duties of the licensees is summarizing. What we've already learned with agency on the national absolutely applies here. One thing I want to point out for broker responsibilities at the bottom of page 43. Anytime a license needs to go back to the commission, the broker has 72 hours to do it. I've not seen that on the exam. I've seen it on other study materials, and actually it would make a great test question. So that's why I want to point it out. When a license is suspended or revoked, we know that any licensee is not engaging in real estate activity. And all listings and property management agreements must be canceled by the broker whose license is suspended or revoked upon receipt by the real estate commission. The broker may not sell any agreements, and the clients may enter into a new brokerage agreement with another broker. We know that a broker is required to furnish a progress report upon request. Remember, there's no 5-day, 10-day, 30-day increment. It's upon request. I also want to point out on page 45 that a broker is responsible for having a written company policy for licensed and unlicensed employees, including what type of agency they offer. Single, dual, appointed, like what types of agency. Then in the middle of page 45, it says supervision required. An employing or affiliated broker is responsible for providing supervision to a salesperson or broker associated with them. And the salesperson is responsible for keeping the broker fully informed of all activities. The commission will not and is not authorized by law to consider conducting hearings involving disputes over fees or commissions between cooperating brokers. We've already heard that multiple times today, right? If you're closing your real estate business, there's a great advertising question I bet you'll get. The broker must remove all advertising. 10 calendar days is the answer. 10 calendar days is the answer. Now, for advertising, though, let's go over to page 47. And we already know those 4 elements that we've got to have on all of our internet and email, not limited to, but specifically on those minimum 4 pieces. Licensee's name, full brokerage name, city and state where you're located, and where you hold a license. I'm Amy Schaefer Real Estate, West Des Moines, Iowa, licensed in Iowa. And then of the 4 brokerage questions, I think you got 2 here under support personnel for licensees. You got at least 2 here. The first thing I want you to know is a broker is responsible for everyone they hire, licensed or unlicensed. I hire an accountant to help me balance my trust account and they mess it up. I can't say, well, I hired XYZ accounting firm and they screwed this up. No, I'm ultimately responsible. You put out advertising that's incorrect, I'm technically still responsible. Okay, the broker has utmost responsibility. We know that, number 1. Number 2, here's the second layer. Let's say a salesperson hires an assistant. So the licensee hires an assistant to help them out with their personal business. The broker is still responsible for that employee, but the licensee that hired them has the utmost responsibility. Okay. Now on page 48 and 49, we've got a list of permitted and prohibited activities that an unlicensed assistant or unlicensed person can and can't do. Guys, anything with negotiating, writing contracts, hosting open houses to the public, hard no. Hard no. What they can do is make copies of keys and open doors for vendors. So a great example is which of all of, let me say it like this. An unlicensed assistant can, no, what am I trying to say? An unlicensed assistant can only do which of the following? Research termite inspectors. Hire a termite inspector. Let the termite inspector into the house. Review the termite results with the seller. They can open the door and let them in, right? Yeah. That's a really good example of kind of a setup. So I would review these permitted and prohibited. And I think maybe just that permitted, even if you just reviewed that, see, it says they can have keys made. They can write advertisements as long as it's been approved by the licensee or broker. They can record earnest money deposits. They just can't have their own account. The account has to be with the broker. They can compute commission checks. They can put signs on the property. Order routine repairs. Like a property manager. For a property manager. Schedule appointments with the seller. Arrange dates and times. But they cannot select vendors. They cannot review documents. They cannot write contracts. They cannot advise clients. They can't even tell a buyer property information. And they certainly cannot host open houses to the public. That's a hard no. Now, property management on page 50, we've got 2 test questions on this one. And the big one about this that I'm going to have you review is what goes on a property management agreement. Now, I mentioned that in the national, but we've got to identify the property, the terms of management, the duties and responsibilities, the length of the contract, how fees are being paid and when. And of course, everybody's got to sign it. I would review that. I think that there's a question that could come up on the national or state for that one. Where I do think that we've got some things to hit is around the financials that's unique to a property manager over maybe a real estate agent. And on page 51, we learn that when a management agreement is terminated, the property management agreement is terminated, it is the property manager's responsibility to notify all of the tenants about where their security deposits are now going to be located and who is now going to be managing the property. And that could be another management company or the property owner. But those tenants have got to know where their security deposits are going. Then at the bottom of page 51, this one was, I know, obvious. We made a lot of jokes about it yesterday. But if you are managing financials as a property manager on behalf of a property owner, a landlord, you cannot write checks out of an account that there's not enough money to cover the check, right? We can't bounce checks. We can only write checks if there's funds available. The other part of this is if you have authorization to manage financials for more than one account on behalf of one property owner, you can transfer money between those accounts, but it's got to be with billings and receipts. You can't just cook the books in the ledger. So I would really focus on that comment that says transfer of funds between 2 or more accounts maintained by the same owner may be made if proper entries are made on the ledger's accounts affected. Transfer of funds between an individual owner's accounts must be done by writing billings and receipts, debiting and crediting the appropriate accounts. Transfers may not be done by ledger entry alone. That last bit of that sentence and the very last sentence I said there is important. We cannot do this without billings and receipts. We have to have those billings and receipts. We cannot do it just by ledger entry alone. The last section, you've got 1 test question with the Iowa Civil Rights of 1965. And here's what I will share is I know that the Civil Rights Act for our federal government was 1968. We just did it sooner, a little sooner. The original protected race, the original Civil Rights Act protected race. And then we've added those other layers over the years. 1 test question, and that's what I think you're going to need to know. If there is any other questions, I think what you know from the national will help you. Just remember who your protected classes are. Don't add anyone to it. Not political party. Iowa doesn't protect veteran status. If the veteran is disabled, they're protected under the disability. Okay, so just really watch that question. But I think for the state, what you really need to know is their original protected class was race. And again, it's been amended over the years, you know, to add in religion, creed, color, sex, disability, family status. Sound good? Sounds good.